Non-compete clauses are no more. The Federal Trade Commission voted to ban them this week for all U.S. workers, arguing the clauses help keep wages down and keep workers in hostile conditions. The new rules will take effect in August and will negate most existing non-competes. But business organizations are already pushing back, including the U.S. Chamber of Commerce, which filed a lawsuit to block this rule. Business and employment attorney Andrew Body is against the FTC's decision. He joins me now along with Terry Gerstein, director of the NYU Wagner Labor Initiative, who is in favor of this ruling. Welcome to you both.
Thank you.
Thank you.
All right, Terry, so let's catch folks up who may not, been following this as closely as all of us have. How is this a win for folks in workplaces?
So non-compete provisions in employment contracts prevent workers from being able to get a job with a competitor of their employer for a given period of time. And increasingly, they've been used in a really broad range of workplaces. The FTC's estimate is that 18% of workers, or around 30 million people, are subject to them. And this means that people, if they get a better job with someone across the street or, in a different part of town, that they're not allowed to move and to change jobs because they have a non-compete. And what this means for workers also is that it ends up resulting to obviously lower job mobility, but also it has a wage suppressing impact because workers can't go get that better job that pays more, and they can't use the threat of leaving to be able to negotiate for more with their employer. So the FTC's the rule that would ban non-competes really puts workers in a much better position and also helps the economy because it's better non-competes. There's lots of evidence showing they're bad for innovation and new firm formation and, bad for entrepreneurialism in various ways.
Well, Andrew, the FTC estimates that banning non-compete agreements could raise wages by nearly $300 billion a year. Why is it a bad thing?
I'm not sure where they got that number, quite frankly. I had to look into this granularly about 10 years ago when I was the chairman of the Smaller Business Association in New England. And my members wanted the non-compete law to stay the way it was. There were certain legislators fighting that. And so I testified on Beacon Hill a couple of times, and I did some research before I went up there. What I found was very interesting was that in California, particularly in Silicon Valley, they had fewer startups than we had here in Massachusetts. And Massachusetts has enforced non-compete since 1811. Silicon Valley, California, they don't allow non-competes. So there didn't seem to be any correlation between, starting a new business and having non-competes in your state. And I'll also say that the same was true statistically with figures having to do with employment. The unemployment rate in Silicon Valley was about 11.9%. In Mass, it was about 5%. And in the Research Triangle, which is also a place that allows non-competes, it was only 8%. So again, there's a bit of a disconnect between the arguments about non-competes harming the economy and not harming the economy.
Well, Andrew, what's the value add here then to keep these non-competes in place?
The value added, for example, is 89% of the businesses in Mass have 20 and fewer employees. So the companies that are dealing with these traditionally are much smaller entities than something like Dell or, General Motors. So it's very important for them to be able to protect their intellectual property and confidential information, to the extent that they're not undone by some unscrupulous person. So what I found in my practice was that a lot of times the employers were willing to let the people out of the non-compete because either they weren't going into a company that competed directly or they were going to a company that was a lot smaller, and even though they competed in some aspects, most of it was not a situation where they were competing directly. So it's not the case that these things are like handcuffs on people. It really depends on the given situation as to whether people are going to be let off the employment contract or not. And also, I'll say just one more thing. The judges have tremendous power to make decisions in equity on these agreements. I've had judges lower the amount of time that the non-compete was in effect. I've had them lower the geographical area, make it smaller. So again, it's really a fluid situation. It's not something that you could just make one statement about.
Well, I want to read this statement from Lina Khan, the chair of the Federal Trade Commission, on this ruling. And she writes, non-compete clauses keep wages low, suppress new ideas, and rob the American economy of dynamism, including from the more than 8,500 new startups that would be created once non-competes are banned. That goes to your point about small businesses. The FTC's final rule to ban non-competes will ensure Americans have the freedom to pursue a new job, start a new business, and bring a new idea to the market. Terry, I want you to weigh in here. Do you think keeping the non-competes will benefit small business or help them?
Well, there's plenty of, we've heard some anecdotal evidence just now, and there's plenty of anecdotal evidence, from employers and from workers. But what's really interesting that's come out in the past several years is that a number of states have passed laws banning or curbing non-competes in various ways. And so that has created a number of natural experiments, what economists call natural experiments, where they can compare what happens in a state where you ban non-competes or you really limit them versus where you allow them free rein. And there's been a real torrent of research on this in the past several years. And it has overwhelmingly showed that when you allow non-competes, that is harmful for new firm formation. So in other words, states that curbed non-competes had more new businesses started. There was one piece of research that I found fascinating that showed that where you limited non-competes, there were more patents that were submitted, and that the patents were more innovative than where non-competes were permitted. And so, I think the evidence really shows when you look at all of these economic studies, and the FTC, they got 26,000 comments from the public when they were considering this rule. And 25,000 of them were in support of the rule, including from a lot of economists, basically, who started out saying, look, there's a natural experiment. Let's see what actually happens in the real world when we permit or don't permit non-competes. And this was what they found. So, one thing that has been interesting to me, I spent much of my career enforcing labor standards laws in the New York Attorney General's office. And one thing that has been very interesting to me is that non-competes don't actually, it's not as zero-sum and adversarial as it is, as many other labor issues are. There are a lot of employers who do not like non-competes because they want to be able to hire the best workers. And on the question of that judges can modify it and that there's some flexibility. Workers, there's a lot of research out there showing a lot of workers in the U.S. don't know what their rights are. And if they get a lawyered up document that's their employment contract, they're going to assume it's valid. And so if there is an overbroad non-compete, that really has no business being in there, most people end up thinking that it's valid and behaving accordingly and don't look for other opportunities, and they're chilled and end up staying in the job. And so even if you have the opportunity where if it ever went before a judge that the non-compete would be limited, who wants to be sued by their employer and ultimately go before a judge? Non-competes really prevent ordinary working people from being able to get a new job.
Well, Andrew, as we mentioned before we started taping here, we know that it's not a surprise that lawsuits have come or appeals have come in the wake of this decision. The U.S. Chamber of Commerce, as we mentioned, filed a lawsuit voting that this rule would affect some 30 million U.S. workers, and also that it's illegal. Is that your stance here, Andrew?
In terms of the law itself, I don't think that the FTC has the authority to do this. I'm not an expert on governmental law, but this isn't something like what they typically do, which is to prevent something from happening. You know, they issue a regulation. This is preventing something that is already happening from ever happening again. And I'm not sure they really have that amount of power, you know. The non-compete issue is very big, like I said, among smaller companies, which are the majority of the companies in the United States. And I'm sure there's going to be a tremendous pushback on this.
That's absolutely for sure. We will see what happens in the future. Lots of money on the line here, either way. Andrew Botti and Terry Gerstein, thank you so much for your time.
Thank you.
Thank you.